Well, good evening, everyone, and welcome to our seventh Ask the Attorney segment. I am Maya Engel, live in our digital studio, joined once again by Mary Ann Wehr. She is an estate planning attorney for Great Lakes Center for Estate Planning here in Northern Michigan, and we are joined by a guest, as I'm sure some of you have mentioned. So I'm going to let Mary Ann introduce her, but I just want to say Happy New Year to everyone. I hope you all had a wonderful holiday and spent a lot of great time with your family. So welcome to the first Ask the Attorney segment of 2024. And with that being said, Mary Ann, would you like to introduce your guest?
Absolutely. And Happy New Year, everyone. Happy New Year, Caitlin and Maya. I'm telling you, I am so excited about tonight's topic. It's really something that's very near and dear to my heart. It really is a good follow to our last meeting where we talked about a revocable living trust, which is a vehicle that allows you to avoid probate. But not without some process behind it, right? It needs to be, sometimes I've seen trusts that are poorly drafted that don't work, or I've seen trusts that have not been made current with current law that are, don't work well. But more often than not, it's funding problems. So we talked about your trust being a box that you put all of your stuff in. Well, if you don't put all of your stuff in the box, it's not there to meet your objectives. So Caitlin Falenski, Director of Investment from Oppenheimer Company, is joining us tonight. And I'm so thankful for this because she's going to talk to us all about funding and the importance of it. And, we really want these trusts to work for you. They're a lot of time invested, a lot of emotion invested, and a lot of money. So, let's make them work. So, Caitlin, I know you'll do a better job introducing yourself, telling us about what you do than I will. So, not to put you on the spot, but you're on the spot. You're on the spot.
Thanks, Mary Ann. Thank you so much for having me tonight. As Mary Ann said, I am a financial advisor with the firm Oppenheimer Company. I've been doing this since 2011, and I love that you are focusing on the importance of funding the trust tonight, because establishing a trust in general is incredibly important. But unfortunately, if you do not fund it, it doesn't really do you much good. So by putting your trust to work, you're protecting your own privacy, you're providing clear instructions to your beneficiaries, and you're also making sure that all of your assets are accounted for within your estate. So I thank you so much for including me in kind of an overall overarching theme. Everyone's situation is different, so I will be talking about some general rules of thumb this evening. But if anyone has any specific questions, of course, feel free to reach out to me directly. I'm happy to dig into details later.
Awesome. Well, Caitlin, thanks so much for joining us tonight. We are pretty informal. This is kind of more of a conversation. We will stop to take breaks if we have any questions from our viewers. So this is just a reminder for all of you folks watching that if you do have any questions for Mary Ann or for Caitlin, be sure to leave them in the comments below and we will make sure we answer those. But Caitlin, this is something that you kind of already started talking about, but just to back up and get the big picture, what exactly does it mean to trust your fund?
To fund your trust, actually. Yes.
That actually is what I meant.
So to fund your trust, it really means that you're retitling your personal assets so that your trust is now the owner. It doesn't really mean anything changes. Typically, when you create a trust, it's called a grantor trust, which means that you are the owner of it anyways, and you have control over it. So if you retitle things into the name of the trust, you still have full access to it, but all of your assets can pass to their beneficiaries according to your specific wishes. By funding it, you bypass the whole probate court process, which not only can that be expensive, but it also makes everything public information to people. And then it also allows your successor trustees to handle all of your trust specific items without having the court having to appoint a guardian or conservator. So it's a very seamless, clean process that makes sure that your wishes and assets are taken care of after your passing.
And Mary Ann, I feel like a lot of these questions I have are kind of directed towards Caitlin, but if any point you want to chime in, feel free to add anything.
Absolutely. And as we talked last week, A trust is all your stuff. You put your stuff in, you take it out, you can use it, you can sell it, you can do anything with it because, as Caitlin just said, you actually own it. You're the trustee of the trust. The trustee of the trust owns the property. So it's seamless. There's no difference between having property outside of the trust or inside of the trust as far as ownership, rights to use, all those types of activities.
Mm-hmm. Right.
Yep.
So, Caitlin, what assets would you typically use to fund your revocable trust?
Yeah, great question. So really any of your personal assets that you own individually, or if you create a joint trust with your spouse, it can be joint assets as well. So it's anything like your checking account, savings account, investment account, stocks, bonds, real estate. Real estate's kind of a really important one because it's a good exercise to then make sure that you truly own that real estate. So we usually recommend, looking at your deeds, public record, just making sure that things are titled with proper ownership.
So this is maybe a question that some people are thinking, how will funding a trust affect their taxes?
Yeah. So if you do it as a grantor trust where you are the owner, it will not affect your taxes. Nothing will actually change. It treats the trust that you are still the owner of all of your assets. And then whenever you title any of your accounts within the trust, you still use your social security number to be connected to it. Now, like I mentioned earlier, if it is a joint trust, maybe with your spouse, the only thing we usually recommend is to use one of your social security numbers for all accounts. So you want it to be, matching across the board. Don't use yours sometimes and your spouse for others. But beyond that, it really does not affect taxes at all.
Wow. Very good to know. So how do you transfer personal assets that do not have a deed or title?
Yeah, so most assets really don't have a deed or title. A lot of real estate does, but everything else really doesn't. So in order to make it a clean transfer, we usually recommend creating a general transfer document. And what that means is you can list anything in this document. It can be as broad as you want it to be, or it can be incredibly specific if you have certain gifts that you want to give someone. So it can say furniture or jewelry, as simple as that. Or it can say my pearl necklace goes to this specific person. So you can choose how specific you want it, but then you typically sign that document and you keep it with the rest of your trust documents.
Yeah, I'd like to add to that. Yeah, when I do a trust, I will do a real broad assignment, which really assigns all of your personal property now in your possession and any in the future. So it's a very broad assignment of trust. It needs to be signed and notarized. It moves everything into your trust. And then, as Caitlin said, you can get very granular even within that and have an attachment that allows a person to specifically gift specific jewelry, specific art, specific pieces of furniture. And that's always a very good idea to be specific. As we talked about, I think when we talked about probate, oftentimes there's collision with those sentimental, or it doesn't even have to be of high value, but items that I think I used an example of a table. Like Mom said, when she died, I could do anything I wanted to with that table. Oh, but she told me I could have it, so it just kind of helps to stay away from those emotional arguments that can happen when people are grieving. And kind of our whole goal, I think, a lot of our goal with avoiding probate, creating the trust is a smooth transfer of assets, which helps families stay out of conflict as well.
Right.
So I think that helps a lot there.
So we do have a question from Jackson. Jackson is wondering, can you gift all to a minor?
So gifting personal property to a minor. Yeah. So there are different gifts that you can give to a minor, right? So you can gift like My husband loves remote control. That's kind of a hobby of his. And he's like, when I die, this all goes to our grandson, and that would be like gifting toys. I don't think that there would be a lot of tracking of that, but gifting money is a completely different thing. If you're gifting money to a minor, then specific types of accounts need to be set up there, depending on the amount. There's usually a conservator account. There's actually laws and regulations that govern those accounts, and who can actually withdraw and for what purpose for the minor.
So Jackson just followed up. I don't know if this gives any more context, but they said, I am a recent widow with a 16-year-old son.
Oh, I'm so sorry.
Yeah, I'm sorry to hear that, Jackson.
It's a very tough. That's tough.
Yeah.
It touches me as well. As you know, I have a grandson, a daughter-in-law, but my son died before that child was born. So it really is a kind of an emotional thing for me to hear that. And I'm sorry, Jackson, that's the situation that you're in.
Yeah, Jackson, I'm so sorry to hear that. Like Mary Ann said, okay, so I was going to say, if you have any more questions, here's another one. She said, so I would need to assign an adult to oversee.
Yeah, an adult to oversee. So how we would do this in estate planning is, if you don't have an estate plan right now, Jackson, I recommend that you hire a lawyer and get one put together. It can be as simple as a will, depending upon your assets, or we can go into a trust. And trusts are not that complex. They just are ideas that people aren't really used to familiarizing themselves with. But within this estate plan would be a plan for a guardian for your 16-year-old son, a conservator for that child in the event that you were to also pass away before he became age of majority. The other thing that is a good idea, especially when you're talking about a 16-year-old son, is to think about a trust, because a trust allows you to spread an inheritance over a long period of time, use it for specific things. One warning I have often given in these discussions is a child, especially turning 18, who has lost both of their parents, probably is not in a good position to receive a lot of money. It could really delay their development. It could cause, some might be, but most aren't. So I do recommend that you find an attorney to help you with setting up an estate plan. And then that attorney will take a good look at your assets and give recommendations, whether a will is sufficient or a trust is a better vehicle. But certainly, yeah, that's what you would do, is assign an adult to oversee.
Well, thanks, Mary Ann, for answering that. Thank you, Jackson, for asking those questions. I hope you got some clarity from that. And just a reminder, if anyone else has any questions at all, be sure to leave a comment below. But Caitlin, I'm going to circle back to you now. So how do you fund your trust with life insurance policies and retirement accounts?
Yeah, so that is a little different because that's more personal preference. One of the benefits to retirement accounts and life insurance is you tend to put a beneficiary on those policies and accounts already. So if you have a beneficiary assigned, it avoids the probate court and the whole estate process if you were to pass away. So that's where it comes down to personal preference of, do you want the beneficiary to be the trust? That can be a benefit, especially if you have minor children, because then it does allow for that guardianship and it's clear instructions of how that child will receive the funds. But for other situations, it could be as simple as your spouse is the primary beneficiary and your children are contingent. And what that means is that if you pass away, your spouse gets the account. Or God forbid, if you and your spouse pass away at the same time, it then goes to the contingent beneficiaries. So there's a couple different ways to look at it, either spouse and then children, or spouse and then trust, or trust altogether. If it's a complicated estate, if you have special needs children, if there's fighting within the family, the trust kind of cleans that up a little bit. So it really comes down to personal preference and just avoiding probate.
Agreed. Now, one caution with beneficiaries and retirement accounts, and in fact, I'm dealing with it right now, right, is that a trust has, the trust I'm working with has very specific, I didn't draft it, but it has very specific language about how to distribute the retirement account. So it expects the revocable living trust to be the beneficiary. So when I checked the retirement account beneficiaries, it was completely different, sending it all other ways, right? And what's important to understand is you can put anything in the trust, but the beneficiary, what's marked as the beneficiary of these accounts is superior. So that's where it would go. So if I wanted my trust to distribute to my, my younger child at age 25, 30, and 40, however I wanted to set that up, but my beneficiary was my next door neighbor is going to get everything, and all the trust will get nothing. So, that's kind of a gotcha. And that's where a lawyer should look at all of the assets. It's all one strategy, right? The trusts, the will document, the beneficiaries, the titling. It's not individual.
So I think that really flows well into my next question, which is, do you actually need an attorney to help you fund your revocable trust?
It is not required, but I do highly recommend it. And especially working with Mary Ann, she is so thorough with that entire process. And you've already did the work of creating the trust, coming up with all the stipulations, the details, the process. And you want to make sure you do it all properly. You want to see it to the finish line, because otherwise it's just a really expensive piece of paper and it's not doing much for you. So it's not required. You might be able to kind of follow a step-by-step approach, but it's usually safer just to have your attorney walk you through it all the way to the finish line.
That's exactly it. I have, up to this point, I have given instructions. I always do the deeds, and then I give instructions, and I kind of follow up. But I am finding that it's just a lot of detail for people to follow up, whether it's just finding the right paid on death designation from your bank, or chasing down your life insurance beneficiary or retirement. So what I've added this year in my firm is, I have a flat fee package. I'm just going to do the trust funding for my clients, because it is so crucial that is done, or the trust can fall apart. Now, I do see Jackson has a few more questions, and Jackson, I'm going to welcome you to call contact me at my office, and we can talk about the trust and all of the types of things that you're asking about. You're asking, can someone dispute a trust? They can, but remember, it's your property, and you're distributing it in the way that you want to. If it's notarized, witnessed, signed, it's a pretty good document. It's not that I've not seen them disputed, but it's a lot less likely with a trust than it is with probate.
And Jackson, just so you know, I did leave a comment with Mary Ann's phone number and her website. So if you do want to contact her for more information, she said, yes, ma'am. And thanks again so much. Thank you, Jackson, for leaving your questions. We appreciate that. Hence the name of the segment, Ask the Attorney. We need questions in order to ask them.
Exactly. No, we really appreciate the questions. There's no doubt we do. Yeah. But when we get down to the personal nits and gnats, it's just, I'm more than willing to have a conversation with anyone.
Yeah, because of course each person, their story is different. They have their specific wants and needs and whatnot. So things are going to look different for everyone.
Absolutely. Absolutely. Yep.
So to kind of wrap things up, after an estate plan is all buttoned up, the trust is funded, and it's put in a safe place, when is the next time that you should think about updating or reviewing your estate plan?
Yeah. So unfortunately, a revocable living trust is not a set it and forget it kind of document. It's in the name, it's revocable. You can amend it at any time, but it's also a major process that you just went through. So hopefully you're not doing it frequently, but we usually recommend at least every 3 to 5 years, or if you're experiencing a major life change. So, are you getting married? Did you have a child? Did you have a grandchild? Did you receive an inheritance? Any sort of financial, family, any sort of dynamic change, you definitely want to take a look at things and just make sure that all of your bases are covered. And then if you haven't had a big change, still laws can change, which your attorney can help you just kind of inform you of some of those changes. So it's always good to just kind of dust it off every few years and make sure that it's still accurate. And, especially if you list a charity or other areas, are you still passionate about those items? Do those entities still exist? So it's really good to just make sure that it is truly current. But it's not like a monthly process every month, but every few years is beneficial.
I completely agree with that. And in my practice, I offer people like free changes, right, for the first 90 days, because who you think might be the right person for the trustee, you might give that a second thought and you think you're going to change it. So those are pretty simple changes for me to make. And I'm willing to do that for the first 90 days. I also offer what I call is a client care package, which gives my clients the opportunity to call me anytime with questions. So often people are afraid to reach out to their attorneys and they don't ask questions because they think, I don't want to spend the money. I'm sorry, it's getting dark in here.
I just noticed that too.
Yeah. Yeah. So, but they think I don't want, an hourly rate. I don't want to spend the money. I'm not going to call. And that's when things kind of can go awry. Because if you called, we could have nipped it in the bud and taken care of it. So I do have a client care package that allows, I will change anything. Recently, right, Caitlin, we had a huge change in the law around retirement accounts. And it happened in 2020. It's still being implemented. There's still a lot of questions, and in some ways, the IRS hasn't completed their rulemaking. So right, so we're and they call it the Secure Act. So as those things change, I really want to keep my clients' documents current. I try to be proactive, so they're not, to the detail, but I will make changes for laws without a charge as well. So, and I like to see my clients once a year, see how things are going, because small things in their mind might be a big thing as far as their estate planning goes. Yeah, just to keep it current and keep a relationship going is really, I think, really important in this area. And I also think that it's a really good thing to create that kind of lifelong relationship with your attorney, because they get, just as a financial advisor, they get to know you. I was recently on a call with a financial advisor, and my client gave that financial advisor like the most amazing compliment. And I was like, oh, I want to meet you, but long-term relationship. And it's just, these are just, CPAs, financial advisors, attorneys that work in this area. I think we're just all passionate about doing the right thing for people. And that's just it's an important part of my practice that I'm bringing in in quite a major way, like with my flat fee charges, flat fee funding, my funding service that will be just part of my service, the client care package. It's just all about building that relationship. So, and Caitlin, I'm sure you do that with your financial clients as well. You're kind of client centric, aren't you?
Absolutely. Yeah. And we want to make sure that everything is working together. Their estate planning, their taxes, their investments, their full plan really has to work.
Sure. Well, we do have a few more minutes. So is there anything else that we want to talk about? Not about trusting your fund, but about funding your trust that we haven't
trusting your fund, trusting your trust funder.
There you go. But anything else that we haven't really discussed yet that you ladies want to mention?
Maybe I'm always banging this drum, but I think it's very important to use an attorney to do this. These are legal documents, right? And it's really sometimes a very intricate weave of many different laws. Like if you're working with a supplemental needs or a special needs trust, you need to understand Social Security Administration regulations. You need to understand, IRS regulations. Taxing is huge. Whether you pay off debt prior to your death or you pay it off out of a trust, taxes are different. So a trust is making an income when it withdraws money from a retirement account to pay something, and it's taxed at a much higher rate than an individual. So there's just all kinds of moving parts along with trust law, probate law, property law, right? We talked about deeding. You're taking your biggest asset and you're moving it into your trust. That needs to be done well and done right. And I think we've addressed that in someone asked one time, could they do it themselves? My recommendation was, it's your biggest asset, right? I mean, you don't want to make a mistake with it. Could you do it yourself? Possibly. I just wouldn't, so I do probably always sound like I'm really plugging lawyers, but I really believe that lawyers who do estate planning are there with this intricate knowledge that is super important. So that would be what I would say is just make sure that you're working with a lawyer who's very experienced in this, understands the laws in and out, and specializes in it.
Sure. Anything else you want to add, Caitlin?
Gosh, I think Mary Ann covered it all. It's great to be here.
Yeah. Well, thanks again so much for joining us. It's so interesting to hear your perspective of funding a trust. And we still have a couple more minutes. Typically we go until 7:30. So I just want to give anyone out there watching a few more opportunities to ask any more questions. But if you do have any questions and maybe you are watching live, or maybe you just don't want them to be answered tonight, I do want to remind everyone that we have this segment every other week. I'm joined by Mary Ann every single week. Sometimes it's just the two of us. Sometimes she'll bring in a lovely guest like Caitlin. So our next segment, let me look at the calendar, will be Thursday, January 18th at 7:00. So be sure to tune into that. And just a nice little note here from Jackson. She said, thank you so very much for the information. Greatly appreciated by all. Thank you,
That's
Jackson.
wonderful.
That's very nice.
Thank you, Jackson. It's great to get the feedback as well.
Yeah.
We do work really hard at bringing subject matter to this to this discussion that people want to hear. So please, let us know if there's something that you're looking for that you haven't heard. Like Maya said, we meet every other Thursday evening in this forum, and Caitlin, I really appreciate your input and your participation tonight. It's really helpful. So
thank you so much.
Yeah. Well, on that note, it doesn't look like we have any more questions right now. So again, I'm going to sound like a broken record here. If you do have any questions at any point, you can always email them to the Up North Live newsroom. The email is just newsroom@upnorthlive.com. And maybe in the subject line, just say, ask the attorney question. We keep a folder of all those questions and we will get to them next time. Again, you can always leave a comment with your questions below. But yeah, just thank you all so much for joining us today. Again, thank you, Caitlin and Mary Ann, for taking time out of your day to talk about some very important things. It is very appreciated by many. So thank you, ladies.
Thanks.
You're welcome. Thank you.
All right. I will see you, Mary Ann, in a couple weeks. And Caitlin, maybe we'll have you on again sometime soon, hopefully.
Great to see you.
Bye, everyone.
Bye-bye, everyone.